Well, with the U.S. Supreme Court rulings at the center of the news, our guest today, attorney Rachel Lopez from Seton Hall University Law School, joins us to analyze the impact. We hear the government saying, well, it struck down several provisions, and the governor there of Arizona saying, well, the main provision we got to keep. Who's the winner here?
Brian, it's really difficult to understand why Governor Ebru would tout the ruling as a victory, because the U.S. Supreme Court actually struck down the majority of the Arizona law, only leaving 3 of the 4 provisions. Even for the remaining provision, the provision called the Papers, Please provision, which, as you mentioned, allows for Arizona law enforcement to ask for the papers of people they suspect to be undocumented immigrants. Even for that provision, the court adopted a wait-and-see approach. This wait-and-see approach meant that the court did not have enough information about what the law would look like in practice to determine whether it was unconstitutional. But the court specifically noted that, in fact, if racial profiling or other unconstitutional challenges were to arise, that it would, in fact, in the future possibly strike down the remaining law.
So that means that the original point of protest still remains, that Arizona can still have officers approach people and ask for their papers without any suspicion other than they might be illegal undocumented aliens.
That's certainly true, at least initially. Again, as I pointed out, it's going to have to see how it will be in practice. If the court determines at some later date after a constitutional challenge that, in fact, Arizona is using this law to unconstitutionally profile people because of their accent or because of the way they look, I believe that the law would be struck down.
Now, on the Obama administration side, they're saying that, well, this confirms that the federal government does have control over immigration policy. Is that the court reaffirmed that? Is that correct?
The court did reaffirm that. And in fact, it's been held over decades that immigration policy is a federal issue. And this is mainly because, as the court pointed out, it's a matter that implicates trade, investment, and diplomatic relations. It's important for our government to speak with, it's important for our nation to speak with one voice to foreign nationals and their governments. In particular, because any perceived mistreatment of foreign nationals could be disastrous for our country's national security and economic issues abroad.
How do you weigh the response there to say to Homeland Security, well, we're not going to respond to your needs? I mean, is this just a kind of a, well, you messed over me, so I'm going to kick you back, or is that legitimate?
I would say that the Obama administration's rescission of these agreements, which would allow for Arizona local law enforcement to detain people that they suspect to be undocumented, was more, I would say, a symbolic and political decision than a practical decision. The Obama administration had actually already indicated that it wished to phase out such agreements nationally even before the decision came out yesterday. And in effect, there was only 7 agencies in Arizona that had these agreements. And in fact, there are similar agreements that are in effect with Arizona jails and the Department of Corrections in Arizona. So those agencies, in fact, will still have the power to call the federal government and ask for someone's immigration status.
And are these unique to Arizona, or are there other states that have these similar agreements?
It's a federal program, so in fact other states do have these agreements, even though, as I mentioned, the Obama administration does wish to phase them out over time.
So when you look at the overall rulings, what's the impact on other states? Because I read in places that, well, now these other states are going to get to craft similar things.
Brian, I have to say that this ruling really slams the brake on the anti-immigration laws that have been sweeping states across this country. The decision really from the Supreme Court is saying that states should really exercise extreme caution if they want to enforce immigration policies on their own. And
I was going to say, there was an interesting reaction from Justice Scalia in a criticism. Explain what that means.
Certainly. So last week, in fact, the Obama administration rolled out this new policy that they're not going to prioritize individuals who arrived here as children for deportation. Scalia, in fact, pretty much very gruffly rebukes this policy, saying that it's contrary to our nation's immigration policy. But in fact, the majority opinion gave a nod to the underlying power which allows the federal government to implement this policy. But I really should make clear to folks out there in Arizona that this is not a get-out-of-jail-free card. In fact, Arizona could still hold people that are eligible for the program because the Department of Homeland Security has not yet implemented the program, and it's going to take probably a couple another months before the policy goes into practice.
Mm-hmm. Do you see a challenge moving forward against copycat laws in other states?
I do. In particular, I predict that Alabama is going to have a difficult time. Alabama is perhaps more punitive and stricter than the Arizona law. And in addition, it's interesting because the court really said that even state policies that mirror federal ones are unlikely to be upheld.
We certainly haven't seen the end of this whole idea about making new laws with regard to immigration. Your thoughts on where we're headed?
I mean, I think it's difficult to tell at this point. I think it remains to be seen how this law is implemented in practice and what the future challenges are before the Supreme Court. All
right, we'll see what happens. Thanks for coming on board and sharing with us, and we look to have you back again to talk more about these issues.
Thank you for having me, Brian.